The judge will actually collaborate with the government in coming up with hypothetical justifications for a law in order to bend over backwards and uphold whatever the government is doing. So no, you don't get a neutral arbiter.
Hi, I'm Zach Weissmueller with Reason TV. I'm here with Clark Neily. He's a senior attorney at the Institute for Justice and author of the new book, Terms of Engagement: How the Courts Should Enforce the Constitution's Promise of Limited Government. Clark, thank you very much for talking with us.
My pleasure. Thanks for having me.
You open the book by talking a lot about judicial activism, and it's a charge leveled by both the left and the right, often by the right when it's something they don't like, such as a court ruling in favor of gay marriage, or the left when perhaps the court's ruling in favor of political speech, like the Citizens United case. You talk about not judicial activism, but judicial engagement.
Judicial activism is completely overblown in comparison to the much more serious problem of judicial abdication. And by that I mean the systematic failure of judges to genuinely enforce constitutional limits on government power. The opposite of judicial abdication is judicial engagement, which means it's a sincere effort on the part of the judges to enforce constitutional limits on government power.
You kind of identify the point where things went wrong is when the judiciary started embracing the rational basis test. Could you explain briefly what that is and what's wrong with it?
So the rational basis test was essentially invented during the progressive movement and really came into use in the New Deal, when the courts decided that essentially they wanted to throw the doctrine of federalism, in other words, the idea of a federal government with limited and enumerated powers. They wanted to throw that off the back of the constitutional sled, and they also wanted to give the government a free pass to regulate in the economy for any reason or no reason. So they invented this thing called the rational basis test, which is actually none of those things. And what it requires courts to do is essentially invent justifications for government regulation, even when those justifications have nothing to do with the law under review. And I just consider it to be a paradigmatic example of judicial abdication, the opposite of which I argue for in the book, is judicial engagement.
The problem that critics seem to have with judicial engagement is that they see it as the judiciary overriding the will of the people often, because these things have been passed democratically, and then a judge is swooping in and saying, no, this is not constitutional. How do you respond to that? Do you have a problem with democracy? Isn't democracy a good thing?
Democracy is a good thing in comparison to other systems of government like totalitarianism, but it is not an unfettered good. And we don't have a pure democracy in this country. We have a constitutional republic. The Constitution establishes that there are some things the government may not do. And I'll give you one example that I think most people respond to. In the 20th century, more than half of the states in this country had laws regarding eugenic sterilization. And we as a country sterilized more than 60,000 people, most of them young minority women. I don't think anybody is going to sit here and say, well, you know, that's the will of the people, and if those women don't want to be sterilized, they should just go lobby the government to change that law. No, we have a constitution to prevent that kind of thing, and thank goodness.
An important part of your argument rests on the philosophical notion, as you're kind of alluding to, that individuals have rights outside of those that are specifically listed in the Constitution, outside of free speech, the right to bear arms. There are unenumerated rights. Where do you get that idea? The
idea that the Constitution contains unenumerated rights traces right back to the text of the Constitution. So the Ninth Amendment specifically says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. This is a clear textual indication of the existence of unenumerated rights. This is reinforced by a provision of the 14th Amendment, which was ratified in 1868 to try to help stamp out the evils of Jim Crow during the Reconstruction, that the privileges or immunities of citizens of the United States are not to be infringed by the states. That is a clear reference to unenumerated rights, and really the only question is, what are they? I mentioned one before, which is the right not to be sterilized by the government for nakedly eugenic purposes. There are others, of course, and they would include the right to earn a living, enter into contracts.
You identified two very specific textual examples, the Ninth Amendment and the Privileges and Immunities Clause. I've personally never heard the Ninth Amendment referenced in for instance, a Supreme Court ruling. Are these things being ignored by our judiciary?
They are being ignored. The 9th Amendment and the 14th Amendment's Privileges or Immunities Clause are systematically ignored by the judiciary, treated as if they didn't exist. In the famous words of now deceased Judge Robert Bork, they are mere ink blots in the Constitution. I think that is a terribly disrespectful way to approach the Constitution. Every part of the Constitution is meaningful, including the parts that clearly protect unenumerated rights, like the 9th Amendment and the 14th Amendment's Privileges or Immunities Clause. And courts do not have a warrant to ignore those provisions, even though they do.
You're a working attorney with the Institute for Justice, which is a great organization, and everyone should check it out. We'll put up a link so that everyone can look at it. You've seen this erosion of rights up close and personal in the courtroom, I'm sure. The bias that the court has towards the state. What are some of the examples you've run into in your own practice?
It's very difficult to litigate a rational basis case, for example, where you are trying to vindicate somebody's right, whether it's to earn a living in the occupation of their choice, not to have their home bulldozed, simply to give it to somebody to build a nicer home, because the courts are so unremittingly pro-government in these cases. And one example that really stands out for me is when a federal judge in the state of Louisiana upheld as a legitimate regulation the Louisiana law that requires people to have a florist license just to sell floral arrangements. This had a terrible consequence for our lead client, Sandy Meadows, because she was a widow and a high school dropout whose only vocational skill was making floral arrangements. And when the state put her out of business, as they did, because she couldn't pass the completely subjective and arbitrary licensing exam, she was unemployed, and she died a few months later alone and in poverty because the state of Louisiana took away her ability to earn a living in a harmless occupation, and I couldn't persuade a judge to protect her constitutional right to do that work. And it was a really sad day for me, a really ugly, sad day.
Judges are supposed to act as neutral arbiters, disinterested third parties. When it comes to a conflict between an individual and the state, is that the case in America today?
Well, it is sometimes the case that judges act as neutral arbiters. They do so in the context of rights that the Supreme Court has deemed fundamental, which is simply constitutional euphemism for important enough to enforce in a meaningful way. Unfortunately, that is not the default setting of our courts. The default setting is that most rights, the right to earn a living, to own property, to eat what you want, to take medicine that you want, all of these are considered to be non-fundamental rights by the court and therefore not entitled to any meaningful level of judicial protection. Instead, they get rational basis review, where the judge will actually collaborate with the government in coming up with hypothetical justifications for a law in order to bend over backwards and uphold whatever the government is doing. So no, you don't get a neutral arbiter in these so-called non-fundamental rights cases. What you essentially get is two advocates, one working for the executive branch and the other working for the judiciary, who together work together to come up with a justification for the law, regardless of its true constitutionality. And I think that has to change.
All of this rests upon the idea that the Constitution matters. It was written hundreds of years ago by dead guys who wore powdered wigs. What gives the Constitution legitimacy, and why does it matter in 2014?
In a nutshell, I would say this. It's no accident that the U.S. Constitution is the longest-running constitution of any major country in the world, and I think it's because of its inherent moral legitimacy. It's not perfect, but it's about the best that anybody has ever done. And as Randy Barnett argues in his book, Restoring the Lost Constitution, our Constitution is binding in conscience because it so often gets the important questions right. That government should be limited, that individual rights should be respected, and that the government should have to justify its incursions of liberty to the individual and not the other way around. But unfortunately, the judiciary in the last 80 years or so has completely inverted that order of values. And what we need to do is to get it back so that the courts are applying the Constitution the way it was intended, as a bulwark of liberty and not as a blueprint for the exercise of government power, which is how they treat it now.
Clark Neily, thank you very much for talking with us.
It's been my pleasure. Thanks for having me.
For Reason TV, I'm Zach Weissmueller.